2023, the LAPD conducted 681,000 vehicle stops across Los Angeles. Of those stops, 23% resulted in a search of the vehicle. That is more than 156,000 cars searched in a single year, in a single city. And in the overwhelming majority of those searches, the driver had no idea what the officer was legally allowed to do, and what they were not. That gap in knowledge is not an accident. It is a pattern, and it costs people their rights every single day on LA roads. This video covers the exact legal boundaries of an LAPD vehicle search, what they can do, what they cannot do, and the one thing most drivers say during a traffic stop that makes everything worse. That one is coming last. Stay with me. Because the legal framework governing vehicle searches in the United States is built on one document, the Fourth Amendment to the Constitution. It prohibits unreasonable searches and seizures. But here is where most people's understanding stops. The word is unreasonable, not impossible, not forbidden, unreasonable. And in the context of a vehicle on a public roadway, courts have consistently ruled that cars receive significantly less Fourth Amendment protection than homes. Not zero protection, but significantly less. That distinction is the foundation of everything that follows. Number 1. The consent search. This is the most common type of vehicle search in Los Angeles, and it is the one that happens entirely because of what the driver says. When an LAPD officer asks, "Do you mind if I take a look?" That is not a casual question. That is a legal request for consent. And if you say yes, you have just authorized a complete search of every accessible area of your vehicle. Glove compartment, center console, back seat, under the seats, the trunk, every bag, every container, every item in plain reach, all of it, with one word. Yes. California law is clear on this point. A consent search requires no warrant, no probable cause, no suspicion of any crime whatsoever. It requires only your agreement, and once given, consent is extremely difficult to withdraw. Here is what most drivers do instead. They say yes because they believe saying no looks suspicious. It does not. Refusing a consent search is a constitutionally protected right. An officer cannot legally punish you, detain you longer, or escalate a stop solely because you declined a search. The correct response is calm, direct, and simple. I do not consent to a search. That is the complete sentence. Nothing more is required. Number 2. The plain view doctrine. This is the search that requires no permission at all. If an officer is lawfully positioned at your window during a traffic stop, anything visible from that position can be seized immediately. No warrant, no consent. No further justification required. The legal standard comes from Horton v. California, 1990. The Supreme Court established that evidence in plain view during a lawful police observation is not protected by the Fourth Amendment, and LAPD officers are specifically trained to use this doctrine. What counts as plain view? An open container on the passenger seat, a weapon visible in the door pocket, drug paraphernalia on the dashboard, a knife not stored in a sheath, anything the officer can see from outside your window without physically entering the vehicle. Here is what most drivers do instead. They leave items on their seats and floors without considering visibility. They assume the inside of their car is private. It is not. From the moment an officer stands at your window, the interior of your vehicle is no longer private space. It is observable, and observable means seizable. Number 3. Probable cause and the automobile exception. This is where the law moves furthest from what most people expect. In 1925, the Supreme Court established the automobile exception in Carroll v. United States, 100 years ago, and it still applies on every street in Los Angeles today. The automobile exception states this: if an officer has probable cause to believe a vehicle contains evidence of a crime, they may search that vehicle without a warrant. The entire vehicle, not just the area in plain view, not just the front seat, the entire vehicle, including the trunk. Probable cause is a legal standard. It means a reasonable officer, based on facts and circumstances, believes evidence of a crime is present. What establishes probable cause during a traffic stop? the smell of alcohol or marijuana, visible contraband or drug paraphernalia, a nervous or contradictory account from the driver, a prior tip or report connected to the vehicle, information from a license plate database query. What does not establish probable cause? The neighborhood you are driving in, the time of night, how you look, how your car looks, race alone. These factors cannot legally constitute probable cause. That distinction matters. Knowing it matters more. Here is what most drivers do instead. They assume the officer needs a warrant to search their car. For a home, that is largely correct. For a vehicle, the automobile exception has created a legal reality where probable cause alone is sufficient, and probable cause can be established in seconds. Number 4. Search incident to a lawful arrest. If you are placed under arrest during a traffic stop, the legal landscape changes completely. Under Arizona v. Gant, 2009, officers may search the passenger compartment of your vehicle incident to arrest only if you are within reaching distance of the passenger compartment at the time of the search, or it is reasonable to believe the vehicle contains evidence of the offense of arrest. This is a narrower rule than it once was. Prior to Gant, officers could search the entire passenger compartment any time an arrest was made. The 2009 ruling limited that authority, but it did not eliminate it. If you are arrested for a crime where evidence would logically be in the car, possession of a controlled substance, driving under the influence, weapons charges, the vehicle search follows the arrest as a matter of legal procedure. No additional warrant is required. Here is what most drivers do instead. They resist or argue at the point of arrest. This does not prevent the search. It escalates the stop, and it can result in additional charges. The time to challenge an unlawful arrest is in court, not on the side of the 405. Number 5. The inventory search. This is the search most people never anticipate. If your vehicle is impounded during a stop, officers may conduct a complete inventory search of the entire vehicle, every compartment, every container, every area of the car. Without a warrant, without probable cause, without your consent. The legal basis is South Dakota v. Opperman, 1976. The court ruled that inventory searches serve legitimate government interests, documenting the vehicle's contents, protecting owner property, and protecting police from false claims. And those interests override Fourth Amendment protection. In Los Angeles, vehicles are commonly impounded for driving with a suspended or revoked license, driving without a valid license, DUI arrests, outstanding warrants connected to the vehicle, certain traffic violations in specific zones. An inventory search following impoundment is not a search for evidence, it is a procedural search. But anything found during that search is fully admissible as evidence in court. Here is what most drivers do instead. They attempt to retrieve items from the vehicle after impoundment is announced. This can be interpreted as obstruction. It does not prevent the inventory search, and it creates additional legal exposure during an already difficult situation. Number 6. What LAPD cannot search without a warrant. This is the section that matters most, and it is where the law still provides meaningful protection. Your cell phone. This is the most significant protection established in recent years. Riley v. California, 2014. The Supreme Court ruled unanimously. Officers may not search the digital contents of a cell phone seized during an arrest without first obtaining a search warrant. The ruling was direct. A cell phone is not a cigarette pack. The data on a modern phone is categorically different from physical objects, and it requires a warrant. LAPD cannot access your messages, photos, call history, or apps without a warrant, even following a lawful arrest, even with your phone physically in their possession. Locked containers in the trunk with no connection to the stop. If a locked container is in your trunk, and the stop was for a traffic violation unconnected to that container, the officer cannot force it open without a warrant or probable cause connecting it to a crime. This protection is not absolute, but it is real, and it is enforceable. Your home. An LAPD officer conducting a vehicle stop cannot use that stop to enter your residence, even if your vehicle is in your driveway. Even if the stop escalates, your home requires a separate warrant. The vehicle stop does not extend to your property. Here is what most drivers do instead. They hand officers their unlocked phone when asked, or they open locked containers when told to. Both actions waive protections that the law specifically provides. You are permitted to say, "I do not consent to a search of my phone. I do not consent to opening that container," calmly, once, and then stop talking. Number 7. How to refuse without escalating. This is the item that connects everything on this list. Knowing your rights is one part of this equation. Exercising them safely is the other. The correct sequence during a traffic stop in Los Angeles is documented and specific. Keep your hands visible at all times. Do not reach for anything without telling the officer first. Provide your license, registration, and insurance when asked. These are legally required. There is no right to refuse them, if asked whether you know why you were stopped. "I am not sure" is a complete and legally safe answer. If asked to step out of the vehicle, comply. Officers may ask you to exit during any lawful stop under Pennsylvania v. Mims 1977. If asked for consent to search, "I do not consent to a search" is your complete response. Say it once. Do not repeat it. Do not elaborate. If the officer searches anyway, do not physically resist. Do not touch the officer. Do not attempt to block access to any area of the vehicle. Observe. Remember. Document if possible after the stop. The challenge to an unlawful search happens in court, not during the stop. This is the most important sentence in this entire video. The roadside is not where you win this. The courtroom is. Here is what most drivers do instead. They argue, escalate, or physically interfere. None of those actions prevent the search. All of them create additional legal exposure, and all of them make what should be a straightforward constitutional challenge significantly more complicated. Number 8. The one thing most drivers say that makes everything worse. This is what the open loop at the beginning of this video was pointing toward. The single most common thing drivers say during an LAPD traffic stop that directly damages their legal position. "I have nothing to hide." Those 4 words are not a declaration of innocence. They are a de facto consent. When a driver says, "I have nothing to hide," and an officer proceeds to search, courts have repeatedly found that statement constitutes implied consent, not in every jurisdiction, not in every case, but in enough cases that the phrase has become legally dangerous. It does not protect you. It does not make the officer more sympathetic. It does not speed up the stop. It opens the vehicle. The correct statement is not about what you have or do not have. It is about your rights. "I do not consent to a search." That is the phrase. That is the only phrase. And unlike "I have nothing to hide," it creates a clear, documented record that any search that follows was conducted without your consent. That record is what matters in court, not what you said on the side of the road to seem cooperative. Drop a number in the comments right now. How many of these 8 legal boundaries did you already know before watching this video? 1, 3, all 8. I read every comment on this channel. And if this gave you something real today, subscribe. Because next week, I am going to show you exactly what to do in the first 60 seconds of an LAPD traffic stop, step by step. The sequence that protects you legally from the moment the lights come on behind you. That video goes up Thursday. Do not miss it.